properly bounded, are not enabled, do not provide for written description, that are anticipated, that have obvious permutations from other prior art. All of those, I think, are valid analysis of a claim. I think what has happened is we've got a little bit sloppy in our claim drafting, and I think better claim drafting would have muted some of the outrage at some of these things that were being protected or attempted to be protected. And I do believe that where we're seeing problems is specifically in the gaming art. If you do an analysis of what's coming out of the Patent and Trademark Office, I don't see strictly computer-implemented software to improve a computer being rejected very much. And I don't see significantly improper analysis under 101 in the computer arts at the Patent and Trademark Office. However, I do see significant problems in the gaming areas when I look at the actions that are coming out of there, or when somebody asks me to do an analysis, and in some of the biotech areas I'm seeing it. So the answer to your specific question is, I don't think that would be patent eligible subject matter now, but I think it should be, and will be.
I agree with Bob on that. With that particular example, it would be difficult to get an application allowed. But there are actually some arguments that may be available. The Federal Circuit came out with a case last year, TDR Holdings, which was directed, the claims were directed to a website, some evidence that it's directed to reformatting a website. And in that case, the Federal Circuit held that the claims were patent eligible, even the claims were purely software implementation, the claims were directed to solving a problem that was unique about the internet. So what the court found was that the claims were directed to a solution that was rooted in computer technology. In this particular example, what that meant was, because of the existence of the internet, a particular technological problem had arisen, and the claimed invention was directed to solving a problem that was unique to the internet. This wasn't simply an issue of taking a manual method and applying software to it so that now you can do it faster. So now in the computer chess example, one argument that comes to mind is that the way you do computer chess is different than the manual method of playing chess. And arguments should be focused on unique problems that are unique to computer chess that wasn't necessarily present by the manual method of playing chess. And you got to try to convince, at least the prosecution stage, try to convince the examiner that this is a unique problem, and the solution, the claims you're trying to get through, provide a solution that's unique to computer chess, and therefore it's a technological solution to a technological problem. Another way I look at that also is that in one of the USPTO examples, they found patent eligible subject matter where stock data was transmitted to an application that caused the application to update the user interface. When I think about computer chess, it's displayed on the user interface, and if you could show to the examiner that there's something unique about how the calculation is made in a time-sensitive manner, and how that's done to update the interface, that might be another avenue to overcome a one-to-one rejection. Still, at the end of the day, without further guidance, it still might be a tough sell, but I think there may be some arguments now available for that.
Thanks. Let's now move on to the next topic. Long back, historically, when patents first came about, it was kind of a quid pro quo. That is, an inventor agrees to reveal the knowledge of how to practice the invention to the public, and in return, he gets a monopoly for a limited period of time. And the public gets the advantage of learning the invention and being able to practice it, although they have to pay a fee for a short period of time. So to that extent, two important requirements in the US patent
two different ways. I think that the courts have now made a decision that they are two different requirements. And I would say that written description means that it's in your possession. So you possess that information, that invention. Enablement is how you teach others to make it. So I think those are the two separate issues. And they do come up in complex organic chemistry areas where there are several different permutations and several different you can have literally 1 million different substituents in some of these. And the question is, did you possess the particular invention that you had? So that's a different question as to whether you enabled the invention. I think that probably answers your question.
And I'll have a follow-on question to that. How much of enablement requirement can be satisfied, if at all, by declaration practice?
That's a very good question. I would say that the enablement must be in the original specification. So I have seen others who subscribe to a different view, but my personal opinion is that it is the specification and the particular claims at the time of filing that need to be enabled. So I would find it a little bit difficult with respect to a declaration, but I'm willing to ask my friend over here what he thinks.
Unfortunately, since I practice in both fields, we never file declarations in the electrical computer science area. That seems to be a unique plan.
One comment I have on that is that what's unique about the U.S. is one of the few jurisdictions that allows incorporation by reference. So, to the as a practice tip, for some of my clients, if while you could be drafting the specification, it's about to get filed, and all of a sudden at the 11th hour they say, maybe we can cover this subject matter, maybe you're coming across a deadline, and it's possible to add now another 20 pages of specification material that the client may consider essential for enablement. So one practice tip would be, we could incorporate a document by reference, and particularly also if it's another patent application or another patent application or another patent issue patent. I would say if that subject matter is covered elsewhere, and you think it's important for teaching ordinary skill or how to practice your invention, why don't we incorporate it by reference? It's considered as part of the specification, and to the extent the examiner complains that that material is not in the specification at a later date, you could always amend it, but still keep the final date.
Mr. Hattori, what is the standard for enablement, and is there a difference between enablement and description requirement in Japanese practice?
Yeah, almost the same as the United States, and we call the enablement is enablement, but we say the support requirement as a written description requirement. And the position is based on the invention of the eligibility of the invention. But almost the same in the United States, and we also, it's very difficult to argue after the filing date using the declaration of the experimental data. But I have one example about the successful declaration case, which is adhesive case. The specification says this combination is this combination has the advantageous effect, but there is no data what is the advantageous effect. And then during the court procedure, the patentees show the declaration experimental data, the exact data of showing what is the advantageous effect. Then the patent was maintained. So that is a very unusual case, but there is one case to successfully buy the declaration. But other than that, it is very difficult.
Mr. Roll?
So we recently had enablement looked at by our Supreme Court of Appeal, and I'm not essentially what they said is the specification must enable a skilled person to carry out or conduct the invention. So you put that together with, I think the recent, not that it's a recent trend, but our courts seem to be quite patent friendly at the moment. And so they hammer on the purposive construction, not an overly legalistic one. And essentially, you only run up against enablement in a court, again, because we don't have examination. And I think your court will look at it on the basis of an expert witness saying, yes, I understand what's going on. You know, this background stuff, everybody in my field knows what it's about. You don't have to really explain that to me. And based on what I see here, yes, I could conduct that. I think that would be sufficient. They're not going to take an overly technical approach, is my view. And you might only run up against problems where, for example, you have a chemical compound and your example that you provide for manufacturing it doesn't give you the compound, so that you don't have that, you simply can't do it. So there you probably run into a problem. But I think the bar is for enablement is probably at the moment quite low in South Africa.
Covered two topics at this point. If you have any questions on either the subject matter or eligibility or enablement, again, open for discussion right now.
Hi, I'm Vidya from PCS, and my question is with regards to software patents. We just discussed about the abstract idea concept and the fact that anything that can be done by a human mind is not patent eligible. Likewise, business methods. And so in that regard, what I wanted to know is that the patent law does not specify a definition or does not quantify how much complexity or how scalable should an invention be before you decide that it cannot be done by a human mind. There's no such quantification or definition. So where do we decide that yes, because every other software invention we seem to get this kind of a rejection that this is possible by a human mind, it's a human activity, or it's a human organizing activity that involves human organization. It is possible, but the only challenge, again, most of our learned inventors come back saying that most problems that can be done by a computer can also be done by the human being, the only hitch being the amount of time, the complexity of data that's being handled. So when there is no quantification, on what basis do we get this kind of rejection and how do we handle that?
So the test in Alice, which adopted the previous test specified in Mayo, Prometheus. It's a two-part test. It's is your claim directed to a judicial exception, including an abstract idea, human work, organizing human activities? And if it is, then you have to convince the examiner that you add significantly more to the judicial exception or to an abstract idea. So I can already tell you 100% of the time that I've never been able to convince an examiner that this is not an abstract idea. And even in the Alice decision itself, they mentioned almost every idea incorporates an abstract idea. So there really is, I don't think there really is much guidance as to to make the argument that you're not directed to an abstract idea. It cannot be implemented by the human mind, and you're really left with the second part of the Alice test, and you got to show that your claims add significantly more than the abstract idea. In the past, you would make the argument that we're not necessarily preempting the all forms of use of the abstract idea, which doesn't really seem to work anymore with the examiner. So in the past, in the past, before analysis, you might say, we're direct, even though the claim recites using a particular digital algorithm, we're not necessarily, our claims aren't necessarily, preempting the use of that algorithm. Our claims are directed to the processor implementing that algorithm. And now what you got to do is you got to show that it's significantly more. It's that your claims are addressing the unique problem that was created by the technology itself. It wasn't necessarily, even though a human could have done this before, as time has evolved, the use of computers has created a technical problem, and the claim is directed to addressing that technical problem. And I think what's beneficial is when you're drafting the specification, is if you can include what those problems are in the specification, so later on in the rejection, you can point out to the examiner that this is the problem that was created by the existence of using computers. I agree with you. Someone could have done this by pen and paper. It would have taken them 1,000 years. But I agree with you. But this is a specific issue that was created by just using computers, and the advancements of computers has created this problem, and our claims are addressing that issue.
So you think if you could provide experimental data or some kind of study statement that shows that what ideally would take so much time is now possible because of this invention to be done in so much less time, that would really establish a technical effect or the significantly more to show that it's more than a generic processor? Is that sufficient?
Sure. Providing in the software realm, that's one thing.
You're asking an excellent question that really has not been answered by the Supreme Court. I agree with my colleague's statement that you have to come up with something that's substantially more. But nothing is specified by the Supreme Court as to what is substantially more. So what I'm advising my clients to do is to write their application as though they're telling a story. And your story is that you are particularly solving a problem using a particular solution to that problem. That you are in fact bulking up your algorithms in your specification and then probably claiming them functionally, which I never used to recommend, but now I am, so that you've got a lot of meat and detail in your specification at the point of filing. Because I don't believe the Supreme Court is going to stay where it is with respect to the current understanding. They didn't really specify anything. Alice was actually a very narrow decision, if you take a look at it, that has had much wider implementation by the district courts and some of the lower courts. So I would say to you, we don't know what the specific answer is. Your best bet is if you've got a lot of detail in your specification and you are solving a technological problem in a technological manner, you have the best chances doing it that way. And I think you really need to bulk up your algorithms and your details in your specification, not knowing what's going to be patentable subject matter when the office picks up your application.
Thanks so much.
Afternoon, gentlemen. Thank you. That was a very enlightening chat. I wanted to bring us back to the Sekunam judgment for a second. This question is specifically directed to Bob and Soumya. My understanding of the judgment is that the ruling doesn't resolve the question of whether it is possible to draft a diagnostic method claim that will in fact pass the Section 101 filter. And obviously the Sekunam claims were issued even pre-Mayo, I think. But I remember reading somewhere that there was sort of a question about whether, had they added a treatment step to the claims, they may have been patentable. And I was wondering if you had any insights on that.
That's, again, another great question. And that seems to be true anytime you're doing something like a diagnostic method. I've noticed that, and for my clients in that field, I am adding in as many possible steps because you've got the same hurdle you have to overcome, which is, that what is substantially more. And apparently, by adding in the treatment, you are in fact doing more that may get you over the hurdle. The problem, though, in Ariosa vesiquinum was, in fact, that it was naturally occurring in the mother's blood. And I think that's a very difficult one to get over. Really, I do think something needs to be done to clarify. And if you read some of the concurring opinions, first, Judge Neese said, I don't agree, that was pretty, but she is Miss Dissent. So, I mean, that's not really surprising. I think was it Judge Lynn? Or
Judge Finn, wasn't it? The concurrence?
There was the concurrence said, I hate this outcome. This is not the right outcome, but I am compelled to do this by the Supreme Court instruction. Now, I don't quite agree with that. And I do know that there was a petition for an en banc hearing that was denied, so that they were not able to get a consensus out of the Court of Appeals for the Federal Circuit to hear it again. But there is a petition now to the Supreme Court, which I think has a better than 50-50 chance of being granted. And I really want to see what they do with this case. And I think if they blow it, you're going to see the pharmaceutical and biotech industry in the United States seek legislation.
Thanks very much.
And again, in your area, I would bulk up. I would claim it the way they claimed it in Ariosa vesiquinum, but I would add a series of claims that also had the treatment in there, because you don't know what's going to happen. So when my clients come to me, I say, unfortunately, you're going to have to add more claims in. Some that claim it in a narrow way that you want to, that don't have, they're just a diagnostic method or a personalized medicine. But then I add in claims that would have treatment to it as well. And at least something should go to the hurdle.
I'd probably like to just follow up on the same issue because, as you mentioned, a lot of the times once this 101 rejections became popular in diagnostic and other areas, the issue was this: it's a naturally occurring thing followed by a mental step without any concrete steps at the end of it. That's how claims were drafted until now. People just said, therefore there is a relationship and determining a relationship. Once we started putting back in an extra step, whether it's treatment or whether it's